Okay, good afternoon. This is the Board of County Commissioners Board Work Session. It is Thursday, April 27th, 2023. It is 2:03 p.m. This session is set to go until 3 p.m. This is a hybrid meeting. We're at 3000 Pacific Avenue Southeast, room 110. This meeting is being recorded and will be posted later on to the Thurston County YouTube channel. I'm Carolina Mejia. I'm the chair of the board. Joining you via Zoom in the boardroom, we have Vice Chair Tanya Menser, as well as Commissioner Gary Edwards, as County Manager Ramiro Chavez, and as well as other staff members. I'm not sure if we have other guests.
We'll go through introductions here in a minute.
Yeah, and we're going to be discussing the pretrial services presentation on assessment tool.
Thank you, Madam Chair, Commissioners. I'm particularly very excited to have this presentation before you. It has been a long journey that we embarked, I'll say probably maybe 3 years, 4 years ago. And I remember the first conversation we had with Donna with the opportunity to access this grant to take us through this long journey. And it has been a long journey, but I believe you will find in this presentation a valuable asset, a valuable tool, the pretrial services and the law and justice system is going to be able to use with the intent really is to help the individuals involved within the system. And that is really the main goal. There is other peripheral information you will receive, but I believe that is the key element of this presentation. With that in mind, Madam Chair, we also have the two Assistant County Managers, Rob Felder and Robin Campbell here. And at this point, I will give the floor to Judge Schaller, who is with us. Go ahead.
Introductions? Yes. Okay, so I'm Chris Schaller. I'm a Superior Court Judge here in Thurston County. I'm the lead judge on the APPR project. And then I'm going to introduce Carrie Hennon, who is the pretrial services interim director, and then we'll kind of just work our way down and around for introductions.
Hi, Carrie Hennon, pretrial services interim director. Thanks for having us.
And I'm Tanya Anderson. I'm a senior manager with the Center for Effective Public Policy, and we oversee the Advancing Pretrial Policy and Research Project. I'm so happy to join you today.
Thank you. Like Tanya, my name is Jessica Ireland. I'm also a senior manager at the Center for Effective Public Policy, working on the APPR initiative. So I work across the country with various pretrial programs and happy to be here with you today.
Thank you. I'm Nicole Carbone. I am the supervisor of the pretrial services department and have been involved in this project in different aspects and definitely moving forward as our team starts to implement. I will play a big role in that quality assurance process. So thanks for having us.
And I'm Donna Reback. I am the person who coordinates the technical assistance that comes from APPR to Thurston County.
Excellent. So who's going to take the lead? Let me load the.
Yeah, we could have our slides. I'll start us off and then hand it over to the rest of our presenters. So we want to talk mostly about the public safety assessment today, but also give a little bit of background on the broader Advancing Pretrial Policy and Reform project. So I'll let you get slides.
There you go.
Next slide, please. Oh, you are
yeah, you can drive.
Okay.
Yeah. Sure.
If I know how. Do I
Just click or roll.
Okay. So we will review Thurston County's role as an APPR research action site. We'll talk generally about discuss the public safety assessment in particular, and we are training and technical assistance partners here today.
So I think everyone knows in 2019, Thurston County was one of 6 sites selected as a research action site. And this was a project that the Pretrial Services Governing Board approved from Mary Ann Clear, who was our director at the time, to apply for this technical assistance. And we were thrilled when we were selected. And so in July of 2019, our Thurston County team, which was myself, Judge Price, Chief Toma from the jail, John Thunheim, Patrick O'Connor, and Mary Ann Clear, we all traveled to Atlanta for the kickoff meeting. We came back, we were super excited. And I'm talking about all this because of Ramiro's introduction. and started making plans, started meeting regularly. And then certainly COVID was a huge interruption in our process. And so we are all very excited that we are at this point where we're going to be able to work on a big piece of the program and implementing that. So that's what we're here to talk to you about today. And the other sites are up on the screen, including Pierce County. And Pierce County has already implemented the use of the public safety assessment. So we also are able to learn, I think, some of what from their experience, which helps refine our rollout of the tool. And so our advisory committee, I've already talked about many of the stakeholders. When we came back, we created the advisory committee, didn't exist before we went to this meeting in July. And so we came back and we expanded what the working committee was going to be. And everyone is listed in the slide. What I would like to highlight is that we have met every month. With occasionally we've canceled in April when everyone's gone for spring break. But since 2020, so even during COVID, we continued to meet, although the focus of our work during starting March 2020 and into probably 2021 was more focused on our system amidst the pandemic. And we actually received a lot of benefit from being part of this project. Unrelated to the public safety assessment, I think it helped us tremendously during COVID as it related to our day-to-day operations and stakeholder input. And then our vision and mission, I think that the big takeaway, I think, for everyone here for the briefing is that we wanted to do three things through this process. We want to maximize court appearances. We want to maximize people coming to their hearings. We want to maximize release because the fact is that's what the Constitution, statutes, and the court rule say. We start with the presumption of release. And then if certain factors are in place, that's when we start putting in conditions. And then third and important, very important, of course, is we want to maximize public safety because that's the other, you have to do all three things in combination to ultimately have success if you're going to make major changes in the pretrial system. And our vision, mission, and values were all created to support those three main goals of this project. And so the sites are really looking at, and our site to, all of our work has been towards this point, and that is to implement the public safety assessment. And that has been interrupted, I think, because of COVID, and then we are getting close to being ready to implement. And then we changed directors in pretrial services. And I would like to highlight that Carrie and Nicole have done a phenomenal job. Of course, Mary Ann did so much work before she left, but there's still a large piece of work left, and they have just jumped on this project and moved us forward significantly. So very thankful for all of the work that they have done.
We don't need to do introductions again because we've already introduced ourselves, but I will echo what the judge said. Tanya and I work with jurisdictions across the country, and we come in really when we start to implement the PSA, and Nicole and Carrie have been great to work with. They really drive this ship. I think they're
I'm not sure what's going on with the volume in the boardroom, but it's not coming through.
okay. Want me to talk louder?
That will help. Yes.
Okay.
Not
If
sure
it's-
if the recording is catching it too.
All right. If it's not loud enough, just let me know and I can talk louder.
Thank you.
All right. We're going to spend a few minutes talking about pretrial assessment tools in general, and then we're going to get more specific and talk about the PSA, but we like to set the context just initially in terms of what are pretrial assessment tools. So the way we like to do this, and we did it the same with the judges, is really frame up that there's three key questions that a judge really is asking themselves when they're setting conditions. And the first is, whom will we release and whom will we detain and why? And really this becomes important because as a community, you don't want to release somebody who poses a danger, right? Because we all know there's harm to the community when that happens. But likewise, you don't want to detain people who can safely be released because that can result in unnecessary detention and financial costs to the county. We know that that can be a big expense that the county pays. But when you look at the second question, you also want to think about who will we release and why. As the judge said, I mean, release really is the presumption, and that's where you start. So once you've identified they're going to be released, this is really where the PSA starts to help because it will identify what could be some appropriate release conditions. And then the third question is how will we detain people and why? Certainly you want to make sure that legal process is followed, that they have, protections and things like that. So these really are the three questions that we think about as we approach this work. The PSA and any other assessment tool, it does not answer question one. It is not telling the judge who to release and who to detain. And it's not telling the judge how will they detain the person. Again, the PSA and other assessment tools, they really work to help understand if the person is released, what would be appropriate release conditions. So that's what that is highlighting. So on the next slide, I want to think a moment, if you could advance one, about why do we do pretrial assessments, right? And the answer is right there. You are trying to predict. You want to know who's who when it comes to pretrial release, who is likely to succeed. And when we talk about success in pretrial, we mean who is going to appear at court and who is not going to appear. Legally in the pretrial space, those are the two things that you need to be concerned with. So you want to predict and understand this because this allows you to intervene sooner. So for example, if you predict and you know that somebody has a high likelihood of not appearing in court, then that's where Nicole and the pretrial services really can step in and offer court reminders and do things to mitigate that risk and help the individual be successful. So again, the key point with this slide is all pretrial assessments, they really work to predict. And again, in pretrial, you are predicting court appearance and public safety. So how do all assessments work? So when we're looking at assessments, particularly pretrial assessments, and again, we're still general, we haven't gotten to the PSA yet, is they all do several things. They have this in common, is that they use information from the past to predict the future. And what you have in front of you are generally things that you see in almost any assessment. They look at other pending cases, prior failure to appear, prior convictions, prior sentences, right? You're looking at the past criminal history to try to predict the future. Oftentimes you see that this is coupled with current information, such as the person's age or even the charge. What I like to highlight, and we really highlighted this for the judge, is we do this sort of prediction in other areas, right? Car insurance is the best example. And I always share, I have a new driver, I have a 17-year-old. And so when the insurance is predicting your rates, they do exactly what this is saying, right? They're using information from the past, your driving record, things like that. They're using some current information, such as your age, to predict your future activity. So this concept of using past information to predict the future, it's not new. In general, it may be new in the pretrial space, but it's not something new overall. So how do all actuarial pretrial assessment tools? So first I want to highlight, there are various tools across the country. There's several of them listed there just to make sure we all understand the acronyms. The PSA is the Public Safety Assessment. The VPRA is the Virginia Pretrial Risk Assessment Instrument. The ORAS is the Ohio Risk Assessment Instrument. The CPAT is the Colorado Pretrial Assessment Tool, and the PTRA is the federal assessment that's used. So they are all actuarial assessment tools. They all work the same in that they're taking information from the past to predict the future. And Tanya will get more specific about the PSA, but what is different with the PSA is that it is going to provide individual scores for new criminal activity, failure to appear, and new violent criminal activity, where the other assessments produce one composite score for all of those. When we say an actuarial tool, I like to stress what this means is that it's scientifically based. It's not just gut or intuition, or I think this is a factor that makes sense. It means it was proven by the data and the research to be statistically valid in terms of predicting pretrial failure. And really that pretrial assessments, what we do stress to the judges in particular, it's a piece that they look at, okay? It's a tool in the toolbox. It's not intended to make decisions for them. And so it provides additional information, but it does not replace judicial decision-making. So you may be asking, what do pretrial assessment tools measure? Well, they measure risk of what? And I just said what the risk was, right? You're looking at public safety and court appeals. So that's what you're measuring. But you also want to know how much risk. If this person were released, what is their risk? How likely are they to come to court? How likely are they to commit a new offense? So that really is what the public safety assessment is going to help do. It's going to help provide specific information on risk of what and how much risk. The one thing I do want to be clear about, though, when we talk about risk of what, there are some things that the assessment does not measure, okay? It doesn't measure flight, and it doesn't measure, a technical violation. The PSA, as well as the other type of pretrial assessments, it really is designed to measure, like we keep saying, failure to appear and new arrest. And as we'll get into, it does flag if there is a likely increase for future violent activity. But as far as other terms or other types of failures that could happen pretrial, that is not what pretrial assessment tools measure. They're very specifically looking at court appearance and public safety. So before we switch gears and now get more specific with the public safety assessment, are there any questions or clarifications we could provide up to this point?
So new arrest isn't always the same as public safety.
So that's a great question. And so new arrest for a specific offense, when you're looking at the public safety assessment, it will flag for future violence. So you have new arrest for anything, and then you can have new arrest for a future violent offense. Does that answer that question? No?
Yes.
Okay.
For now.
So now we're gonna switch and talk about the public safety assessment, which is what we use the acronym PSA. PSA in Thurston County.
What?
PSA in Thurston.
Oh.
So we move forward into implementation with the public safety assessment. These will be completed prior to any preliminary appearance, either in district and or superior court. I think about a year and a half ago, pretrial services had expanded universal screening in the Thurston County Jail. For a long time, we were only providing services in superior courts. So I just want to make sure everyone understands that we are providing these services in both superior and district court. So the release/detain decision will be made by the judge, and the public safety assessment will be completed by our department when an individual is 18 years of age or older and charged or addressing potential charges in the adult criminal legal system. And the PSA has very specific criteria, which is kind of what we're listing through. And they have to have been arrested and booked into the jail. Their case is pending disposition, and they will appear before a judicial officer for either a pretrial release decision because they've either been charged with a new criminal offense or they've been arrested on a warrant for pretrial failure to appear. And so just a few takeaways from this is, as we move through training and into implementation, we will be having some changes with the types of cases that we may currently complete a screening report on versus once we go live with the PSA, because we're going to be working off of the public safety criteria. I'm sure Jessica and Tanya may cover a little bit certain criteria such as like the 18 years or older, as well as like if an individual is in custody and allegedly commits a new offense while in custody, they do not meet the PSA criteria. Tanya can explain it a lot better than myself, but that was not a sample population when they did the validation and determine these factors. And so we just wanted to highlight, as we move through this process, there's been a lot of education to our criminal justice legal system stakeholders as to these changes.
Okay, so let's talk about the PSA and what makes the PSA unique. So in 2013, Artiventure set out the goal of developing a tool that could predict 3 factors. failure to appear, new criminal arrest, and the potential for new violent criminal arrest. But what they really wanted to do was create a tool that did not require an interview, that can be done using administrative data. And we saw that that is real important because during the pandemic, what happened to the pretrial agencies that required an interview? It shut their operations down. And so the fact that they could create a tool that would only require administrative data can be used nationally over the United States, and more importantly, would not require a cost to use it. Now, yes, there is a cost for resources, right? Because you have to have staff to be able to score the tool. But that was their goal. And so they created the public safety assessment, which gives those 3 scores: the potential for failure to appear, the potential for new criminal arrest, and then the potential for new violent criminal arrest. In looking at the PSA development, the PSA was developed using 750,000 cases from 7 state court systems, as well as the federal system, as well as Washington, D.C. So it was a large population that this tool was developed and validated on. And as said, they developed it using the factors that had the strongest predictors of pretrial failure. And when we're talking about pretrial failure, we're talking about not reappearing in court or getting rearrested during the pretrial phase of their case. Those are the 2 things that we're looking for in terms of pretrial failure. And the researchers tested hundreds of correlations among several potential factors, and then they came up with the most predictive factors that can predict the likelihood of pretrial failure should this individual be released during the pretrial phase of their case. And so as a result, when the researchers looked through the factors and identified the strongest predictors for failure to appear, new criminal arrest, and new violent criminal arrest, they concluded that the strongest predictors of FTA, which is failure to appear, NCA, new criminal arrest, and new violent criminal arrest, were related to the person's current charge, criminal history, and age, which is administrative data. And the person's age is the only demographic information that's taken for the individuals when completing a public safety assessment. So what you see here is based off of development, these are the 9 factors. These factors had the strongest predictors for pretrial failure. And so the first one is age at current arrest. The second one is whether or not the current offense was violent. Then the current offense is violent, and if the individuals were 20 years or younger, pending charge at time of arrest, a prior misdemeanor conviction, a prior felony conviction, whether or not there was a prior conviction for misdemeanor or felony, and then a prior violent conviction, a prior failure to appear, and this is pretrial, in the past 2 years, or a prior pretrial failure to appear older than 2 years, and a prior sentence to incarceration. So I want to also point out that while face value here, when you look at it in your packet, it may seem like really simple to go and to score this and to come up with this number. But in fact, it takes a lot of work from the pretrial staff in order to score this. They're running national criminal history, local criminal history, and then they have to look through the files to be able to score this information. So they do a lot of work, and we train the assessors today as well. So when we look at the factors, you'll see here on the next slide is that each factor does not populate the 3 scores. Each factor has its own factors that take into account whether or not they have an FTA, what their score is, the NCA, and a new violent criminal arrest. So you'll see here in this slide, in order to populate the failure to appear, it's the factors of pending charge at time of arrest, whether or not the person had a prior conviction, whether misdemeanor or a felony, prior failure to appear in the past 2 years, and prior failure to appear older than 2 years. Those are the only factors that are populated to give you the FTA score. And then if you look at the next column for new criminal arrest, you'll see the factors by check mark that indicate whether or not what populates for the new criminal arrest score, which is age at current arrest, pending charge at time of arrest, prior misdemeanor conviction, prior felony conviction, prior violent conviction, prior failure to appear in the past 2 years, and prior sentence to incarceration. When you get to your last column was the potential for new violent criminal arrest. This is not going to give you a score, but what happens here is that once the person scores enough points, it generates a flag to be able to let the courts know that this person was flagged as having a potential for new violent criminal arrest. So these factors that take into account in order to generate that awareness for the courts is current violent offense in 20 years or younger, pending charge at time of arrest, prior conviction, whether or not misdemeanor or felony, and prior violent conviction. So those are the factors that are gonna populate to give you whether or not that person would be flagged for the potential for new violent criminal arrest. So if you notice here, there is one factor that is relevant for all three scores. And you'll see that that's what? Pending charge. So that's real important. And that factor there is what we really work on too, to make sure, along with the other factors, that the assessors are actually scoring, because that pending charge takes into account all three factors in terms of populating the score. So before I move on, I want to stop and see if you have any questions so far in regards to what has been presented.
Questions, Commissioner Edwards?
Yes.
I guess maybe my only question right now would be, do you ever consider the line officers that are the corrections officers and maybe their comment? Because they can pretty much tell you who's coming back and who, because of chemical dependency or attitude, whatever, they pretty much have it figured out. And I'm not saying that this isn't all good, because it is all good. But as kind of a barometer check, it wouldn't hurt if you don't do it. I'm just suggesting that. I mean, I will say that, just maybe so you folks know where we're coming from. Ty and I come from two different backgrounds. Him being a defense attorney and me being a cop, you know, so. And we often look at things from a different perspective, but I would point out that, how many years ago did we stop that jail expansion? More maybe. I don't know. How long ago?
About 2.5 years.
Yeah.
When you stop it.
Lockdown.
Anyway, just, but you know, kind of coming at it, that it's not working, right? And, so just kind of interesting, I think, to throw that out there just for your background.
So what I would add, I know we didn't get time to do full formal backgrounds, but I wasn't a cop, but I spent my first 10 years working in the sheriff's office. So I worked directly with inmates. So I do hear what you're saying. And I think what we would point out with the PSA is this itself doesn't take that into account. But as we've said, it's a tool in the toolbox, and the judges certainly have more information available to them. So if, you know, they do take other things into account when they're setting those conditions.
And the pretrial services report is going to be changed quite a bit. And I think that Carrie and Nicole can talk about that probably the most. I think that currently the lawyers rely upon the pretrial services report, and most of their arguments come from the information that's in that. I do believe that lawyers will need to take a more active role in providing us information that they think is relevant, because pretrial services, I believe, I don't want to speak for them, I think they're trying to give us information that can be verified by a source. They're not doing interviews anymore and are trying to get away from providing us subjective information, such as their recommendation. Because of course, from pretrial service officer to pretrial service officers, we get different recommendations on the same facts. But I do think that the lawyers, whether it's the prosecutor or defense, they still have the ability to argue to us any information that they want us to know that they think is relevant when we set conditions of release. We are not simply going to take a score from the public safety assessment, and it says 1 on failure to appear and 1 on new criminal law violation, and say, okay, you're released. It won't work like that. This is just to better inform us on a, when I use the term neutral, I mean on a statistically tool, so that we treat people who are similarly situated the same, which our data shows that we don't, because some people are detained in jail, some people are released. And statistically, when you look at their criminal history and their failure to appear rate and the charge, you have 1 person in jail and you have 1 person out. So we're trying to just, I think, get more information that's statistically validated so we can make good decisions. So your information that you're talking about, this really long answer, I do think still can come to the court, but it has to come through the lawyers.
Yeah, I mean, you've got people like Ted Bundy that are the slickest guys in the world on convincing, you know, that they're the nice guy. This is all a mistake. You know, so some of them are super sharp. So you have to, You have to be aware of that.
The only thing I would add to that too is pretrial services has access to the jail database through ADAMS. And so we are able to see if an individual meets with like a mental health professional, we're able to see some high scope notes as well as any notes in their housing as well. So if there are concerns related to behavioral health, those are things that we do have access to as well.
Just so you know, I ran the jail here for many years.
Okay.
So previously the sheriff
Oh,
for many,
nice.
many years.
Okay. Great question. So any other questions before we move on?
Commissioner Mensah, any questions?
I think I'm gonna wait to see how this, because you kind of touched on one of my questions about the, you know, how it's gotta be in a score has to be then in connection with a person that's facing a current charge, and because that's gotta factor in.
That's coming in,
Mhm.
coming up. I mean.
So
So
getting, go ahead.
my question relates, you know, with risk assessment tools, right? They're just as good as the data that's collected. And so where is this data being collected? And, you know, issues I see, right? Like when we look at our criminal justice system, it's, you know, there's a lot of systemic issues that are happening through it. And I feel like this tool can assist, but there's just the data is kind of where I'm having the issues or the questions about.
So I think what you're asking in regards to, so the validation, so there, first of all, Thurston is in a very unique position. And I say that because a lot of jurisdictions that implement, they don't have a validation. But because you've been part of the Advancing Pretrial Policy and Research Project, you have the fortune of having the tool validated for your population. So your data has been looked at and analyzed to determine if the public safety assessment is validated for your specific population. So the tool was developed and validated using 750,000 cases, but taking it a step further, your data in Thurston County was actually evaluated, and then the tool was validated specifically for Thurston County.
Can I just add to, so one of the issues that comes up a lot in talking about risk assessment tools is, does this exacerbate systemic racism, disparities that we see in our criminal legal system? We've talked about this a lot, and I think, you know, the basic premise that this is built on criminal history and certain populations are much more likely to have criminal histories. That's true, but criminal histories are coming before the court already. What this and are used to make all of these decisions already. What this tool does is increase transparency, increase consistency, and we hope give us a lot more data going forward to look at different populations and, you know, how are release and detention decisions made, how are release conditions set. So it is not a panacea. It will not eliminate any disparity in our system, but it gives us a much more kind of consistent, transparent tool to look at. Does that help? Is that related to your question, Commissioner?
It is. Okay. Thank you.
I just want to add to, with the validation, it did look specifically at, was the tool predicting differently based on gender or race? Because that would be a concern if it was, and it found it was not. And so that should be reassuring that you're not implementing a tool that is making something worse for one group versus another. And so those are the things, to Carrie's point about continuing to collect data, is you want to make sure that you are continuing to predict equally. And then to Judge's point, I mean, you wouldn't want to see, quite frankly, Tanya and I have a similar criminal background in a similar offense, and I get released and Tanya gets detained, but we're both a 3-3 on the PSA. That's where you should start to have concerns, and that's the type of data that Carrie and them are going to collect. So you know that it is being used equally, transparent and consistently. Good question.
Yeah, good question. Want to go to the next slide?
Yes, I do.
So the researchers also determined the weight of each factor and how to construct the final scores. And so they looked at it and said certain factor weights, they differ by outcome. So the scores reflect 2 scales and a potential flag, as I've been talking about. So for failure to appear, they'll get a scale score of 1 to 6. For new criminal arrest, they'll get a scale score of 1 to 6. And then for the new violent criminal arrest, the potential of that, it'll either be flagged a yes or no. So the courts will either be told, yes, there is a flag for the potential for new violent criminal arrest, or no. But the other two factors will give a score of 1 to 6.
Could I ask you a question on that? How do you determine the 1 through 6?
Great. So the 1 through 6, and I think we're gonna get to that here. I don't know. I don't think, yeah. So
We'll get to it.
Yeah, well, I don't think we're gonna have the points and scales, but what happens is that once the pretrial officer scores each of the factors, there is a raw score. So nothing is gonna be done manually. It'll be done through the automated system, case management system. So it then generates a raw score that then in turns populates to a scale score. So that's how the actual scale score comes out of 1 to 6. So each factor, if it's answered yes, it'll be assigned points like 1 point, 2 point, or 3 points. And this is in the raw version, and then that gets converted. So that's what we don't have here today, but that's how it gets converted to the scale score.
And how does substance abuse fit in here?
So the substance abuse does not, because this is all administrative data. It doesn't require an interview.
But again, it doesn't mean that's something that the judge doesn't take into
Right.
account. So when they developed and validated, they tested honestly hundreds and thousands of different variables to see what was predictive of that pretrial failure. And it wasn't that substance abuse, mental health, residency, things like that weren't predictive, but what they found is it didn't add any additional predictive accuracy. So you could still complete an assessment only using administrative data and not an interview. And then the judges certainly could take those things into consideration. We can get for you the points and scales. That's a very granular thing that we spend more time with the staff. In terms of
I
how
don't
you
need
score.
that. I just wondered.
But yeah, that is the premise. There's points assigned to each of them. All right. So I think now we're on to talking about validation. So what we just talked about really answers risk of what, right? We know that's what judges are taking into account: failure to appear, new criminal arrest, new violent criminal arrest. And when we talk about the validation, it really starts to answer that question, how much risk? So the PSA was developed, like Tanya mentioned, and then it was also validated nationally. So they used 500,000 cases across the state, across the country, and what they found is it is very accurate. It's continuing to predict strongly. I will share with you that Thurston County did have their own validation, and the results that I'm going to share with you from the national validation really mirror what Thurston's were as well. And so you should feel good that you are producing, rates that mirror the national. And I'll point out there's 1 or 2 in particular that actually are a lot better than the national average. So the way that this all starts to come together, and I think it somewhat starts to answer what you were asking, is based on the factors that are present, those 9 factors, and the 3 scores that are produced. The first one is appearance rates. So the way you look at this, you see the scaled score, that's what the 1 to the 6 represents. So an individual on the national validation that scored a 1 was likely to appear in court 89% of the time. And you just read that all the way down. So if you go to a 6, someone who scored a 6 was likely to appear in court 65% of the time. Right? So we like to talk about things in terms of success because people are most often successful. So any questions on how you read that data for appearance rates? Okay, so again, we're looking at how much, risk of what and how much. So the next one is arrest-free rates. Again, you read it the same way. Based on the scaled score of 1 to 6, it produces a number that's on the report for the judges that correlates to a success rate. Looking at the national validation, someone who scored a 1 was likely not to be arrested during the pretrial period 91% of the time. So you would read that the same way all the way down to the 6. This is where Thurston County really did stand out in terms of their validation. Because someone who scored a 6 in Thurston County based on your validation data, that actually percentage changed to 70. And so some 70%, I know. So an individual who scored a 6 and released, they were 70% likely not to be rearrested during the pretrial phase. So that was, a big jump that we wanted to highlight. So any questions in terms of how you would
So it
look?
was just the score 6 is the.
No, the 5 was much higher
The 5
too.
is higher.
So
but
it's
not
the same, it still have the same trend then.
Right.
Trend line. Okay,
more
okay.
successful trend. Yes. So then the next one is what Tanya talked about, the violent arrest free rates. And I have two slides that I'll show you here. You don't get the scaled score on the report of 1 to 6. This is just showing you for your information how each incremental scaled score would break down. So an individual who is a 1 would be, my eyes are bad. 99% of the time, if they were released, they would not be arrested for a new violent offense pretrial. So you would read that the exact way. But what I really like to highlight is, again, on the report, this just comes in as a yes or no. Either yes, you have the violent flag, or no, you don't. So the way you would look at this is for individuals who do not have a violent flag based on the national data. They did not commit a new violent, they were not arrested for a new violent offense 98% of the time during pretrial. And for individuals that did receive the violent, they were not arrested for a violent offense 92% of the time. So I know violence is a big concern. It's a big concern for the community and should be. But what we like to point out is that new violent criminal activity during the pretrial phase actually isn't as common. But it certainly does happen and is something we know the judges take into consideration.
Let me add something just really quick.
Yes.
So one thing that the PSA does not take into account, which you know what the questions are, because that's been presented, but specifically it does not take into account domestic violence or interpersonal violence cases and potentially sexual assault. We have a separate work group who is specifically looking at those type of crimes and looking at what is available as a pretrial tool or measurement, so that we have that information in addition to the PSA. Because, for example, I mean, potentially you could have I was going to say a 2-2 on failure to appear in new criminal law and not have the violent flag. But based upon other information specifically related to that type of crime, the judge may still then say, bail is appropriate, or not necessarily follow some sort of release matrix. And so we have specifically called out that area that is really important to us and something that we put a lot of focus on. And Judge Thomas is the head of that work group and will be making recommendations to us about what else we should be specifically using in conjunction with the public safety assessment to address that type of case.
Is there something in your data and validation studies and all that show that this needs to be correlated to different types of crimes? I mean, DV is one, but I can imagine others that you would get different results, or is this shown to be predictively consistent across whatever the current offense is?
It's based on the current offense. So it was based at time of arrest. What were they charged?
What I'm saying is if I've got somebody who's a DUI, and I got somebody who's a DV, and I got somebody who's a robbery, I can still do the same 9-factor non-interview point scoring and get a consistent set of predictors.
I think on DV in particular, what we talked about this morning is it's not designed to assess for lethality, which is something we do care about. There are other tools that are designed for that. This is not kind of tailored to that particular issue. Examples, but that's, I think, a big one on the mind of a judicial officer.
But you can still use the tool. I think what you're asking, can you still use the tool across all charges? Yes, and it's still going to score. It's just not, when you get to the DV, it's not going to separate lethality, the risk of lethality. So this is just pretrial. The risk of pretrial success or failure.
All right, so just to kind of summarize this, we like to highlight the success rates and point out people on pretrial release succeed in the vast majority of cases. We saw this on the national validation. You certainly see it in your local validation. If you were to average all the studies that have been done, what we say is approximately 80% of released people succeed. That's on average. And that people are very unlikely to be arrested for a new violent offense while on pretrial release. Although again, we know those are the things that we certainly are very concerned about, especially with the community. All right, before we actually talk about the release conditions matrix, any questions on the PSA, outcomes it's predicting, success rates?
Are we gonna have any time here to get We're not gonna have much time, are we?
Yeah, I was gonna do a time check right now.
Maybe we can improve on the presentation, give some 5 minutes or so for the board to ask some questions.
Sure, okay. So let's go through the release conditions matrix real quick. I'll kind of just highlight what it is because I'd like you to get to actually talk about it. So once you complete the PSA, you get the score. You've heard us talk about like a 2-2 or a 2-3 that represents your new criminal activity and your failure to appear score. So the PSA is assessing people, and then the release conditions matrix is where you put it together and you really start to identify what would be appropriate conditions to assist that person if they were released. And so there's two sections, and I'm just gonna actually switch to the Thurston County PSA conditions matrix, so you can explain.
As a part of this whole process, there's been lots of work groups, and one of those specifically was the conditions matrix. I was not a part of that, but that composed a representative from pretrial, judicial officers, attorneys, both from Office of Public Defense, Prosecuting Attorney's Office, as well as technical assistants through this process to really sit down and have a conversation that if a release decision is made, how do we take these two outcomes related to public safety or failure to appear and public safety, and how does that then correlate to services to help people succeed? And so on the left of this grid, you'll see the 1 through 6, that's the failure to appear score. And then across the top is the new criminal activity scores. And so everyone's gonna generate those two outcome scores. And so if, for example, if someone is a 2 on the NCA and they're a 3 on the FTA, they would fall into the category of a 1. And so I think this group really had to sit down and look at, what level of services for those that might need a lighter touch versus those that need a little bit more support. What level of services is appropriate for them to get and consistent. And so if we kind of go into the next slide, this will tie in with our release conditions table. So as we saw in the release conditions matrix, it's a scale of 1 through 4. And then that's going to tie into what level pretrial services will be monitoring that individual on. And so that level will then determine what types of conditions are ordered, if they're getting court date notification, how often they're checking into pretrial services. So for example, a 2 would report to pretrial services once a month, whereas a 4 is going to report to pretrial services once a week and report in person to our office every time after court. And so this work group compiled a lot of good work to ensure that we have a consistent approach as to how we are monitoring cases and to ensure that there is consistency based upon their levels of success in the pretrial phase.
Okay, so putting that all together, we have a couple screenshots of, we've talked a couple times about, well, what this report that will go before the judicial officer, a defense attorney, a prosecutor. So this is a screenshot of what our pretrial screening report will look like. So on the top, basic background information, who are we talking about, et cetera. And then kind of building on what Nicole just talked about. So kind of leading with this release level, and we wanted to leave this language on there. If a judicial officer orders release, the release level is. So that goes back to that release conditions matrix. So the if still puts the release decision where it belongs, in the hands of the judicial officer, but says if release is ordered, then, if this person is a 3-2, you'd look at where that falls on the release conditions matrix, and that's the level of supervision that pretrial services will provide. So that's sort of the kind of headline there in that box up at the top. Then it will show where did that come from? That came from these scores on failure to appear, new criminal activity, and the violent offense flag or not. So that's sort of the first part of the report. Next slide shows the next part of the report. We will then on every report have these charts as sort of a reminder to everyone, to the consumers of this information. What does that even mean? What does that 3 mean? Oh, it means, or maybe in this case 4, it means that the % likelihood of success, and now my eyes really can't read that, is whatever that number is circled in green. Maybe on your slides you could read it. So these, so the charts for each of those 3 scores provided with success, and then it will show answers that built into those scores. So the 9 factors and how did this individual at this time, how were they scored on those 9 factors? So that will be the report that goes in front of the, again, judicial officer attorneys to really inform these discussions that happen at the preliminary hearing. Okay, what's next? We have had a busy full week, one more session left of pretty in-depth training for pretrial services staff on actually how to score this, all the definitions, all these different factors. And then a session with judicial officers, prosecutors are tomorrow, defense attorneys a couple days ago, one more session with the judges next week. So providing a lot of information, context, background for everyone. We will not fully implement on Monday. There will now be a 3 to 4 week practice period for assessors and then a 3 to 4 week soft launch and a really significant quality assurance process throughout that period. We've written a quality assurance manual. We've set goals for ourselves at what level of accuracy we believe we need to achieve in order to say to the court and the stakeholders, we are scoring this, we are scoring it consistently, accurately. That means reviewing the beginning, all cases, and then on an ongoing basis, continuing to review the scoring to make sure that we are following all the rules and crossing all the T's and dotting all the I's. So 3 to 4 weeks plus 3 to 4 weeks means we believe we will be ready for full implementation in approximately 6 to 8 weeks. Once we meet these internal accuracy goals. And then as part of this quality assurance process, we would, of course, we'll be looking at each and every factor. Are those consistently scored? Providing booster training as needed. And marching onward toward full implementation.
Are you ready for questions now?
I think so. Is that our last slide? Yeah.
I
Yes.
see the judge. I always wait for the judge to
Just
speak.
say really quickly, this project is unlike a lot of projects. I know that commissioners, you always have a lot of different stakeholders come to all of your meetings and participate. And we do have criminal justice stakeholders who meet every week to talk about small things, right? This is a huge project and we have had buy-in by all stakeholders, prosecutor, defense, obviously pretrial, the jail, the sheriff, under the old, under Sheriff Snaza and now under Sheriff Sanders. And we have had the municipal law enforcement involved as well. Chief Almada is the main person who's been on our committee. And so I just want to say that we don't always agree on everything, but what we have agreed to is to move forward and we come to consensus. And I think it's a huge achievement that we are where we are at and that everyone is on board with moving forward with the implementation as it relates to all of the stakeholders who meet on this project.
Madam Chair, are you?
Go ahead, sir.
Nicole gave us a little bit of a, flexible matrix, I guess, depending on the situation that points that the individual might have as far as he checks in twice a week or every 2 weeks or whatever that might be. I didn't hear anything, and don't take this as I'm not critical. I'm an advocate for everything you're doing here because the other hasn't worked. We knew that years ago. So, but when we end up in a situation where maybe the matrix doesn't fit exactly, does electronic monitoring fit in there anywhere? And then you think about maybe peer pressure with these individuals, that affects them sometimes, and besides the chemical abuse. And so there's a few more tools that I see that could be used to alleviate jail overcrowding. I'll just put it that way. That makes it sound like I'm talking about money. I'm really talking about people.
So they can use them. Those are available options that the judges can order, but they're case specific. And so if there's a case specific reason and the judge felt they needed to order that, they could. I think what Nicole shared is just representing in terms of the supervision, what they themselves would provide. That's what it would look like. So there would be that consistency. So
Yeah, and I think on the slide so there's the release conditions matrix, and then there's the following slide that breaks down the 1 through 4 monitoring level and kind of what conditions follow. I think at the bottom, there is a box that says any kind of individualized conditions. And so I kind of highlighted, yeah, the reporting, the monthly criminal history checks, but pretrial services also monitors all the court-ordered pretrial release conditions. So just as Jessica indicated.
I go all the way back to the Anabuse days, you know, and that solves a lot of problems, but apparently somebody didn't think it was the right thing to do. Anyway, no, it's.
Yes, the court can still absolutely order electronic home monitoring, bail, those things don't go away. In any fashion, the court still decides what the conditions of release will be.
So I think we're already with you. I'm trying to figure out what do you need from us?
This actually really with this information.
Information only, yes.
Hopefully helps to understand the purpose and intent of this new tool.
Looking for cheerleaders?
That would be good.
Commissioner Munster, you have questions?
Follow up on what Carrie said. So the data analysis, like maybe Jessica, you said, like, you're gonna be tasked with watching this as it goes and make sure racial groups aren't treated with disparately. And I mean, can you talk more about that, what that's gonna look like and how you're gonna do that?
That's a whole other work stream that I think we have a lot of. It's a area of challenge, a lot of work to do, and super important. There's no doing this without the ability to then look back and say what changed is kind of meaningless. Do you want to speak to what some other jurisdictions have tried, kind of the high level
I think initially,
things we really want to make sure we can grasp?
I mean, long-term, you would want to continue to validate, but validation is a process. So you would need to wait 3 to 5 more years to get enough cases and validate to have a full sample size. But in terms of some of the immediate things, it really goes back to what the judge is saying. I mean, you could have people that are similarly situated and one gets released, one gets detained. So you would want to see over time that people of different racial or ethnic groups are receiving similar outcomes when they have a similar profile. And so that is easy to kind of work with Carrie and Nicole to make sure. We call it concurrence rates, like how often are judges following and how often they're not. They absolutely shouldn't follow 100% of the time because we know it's a tool in the toolbox. But again, you would want to see people were in a similar situation were being treated similarly. And if you weren't, that's where you would go back to the work group and start having a conversation. So hopefully that's helpful.
And pretrial is going to track data. I think what you're asking, like, is pretrial going to track data to see the outcomes? Yes. They'll track like who's on the case. So what was the disposition? What was the PSA score? What was the outcome? So they have to track that in order to know how effective the tool is and to look at those racial disparities to see if anything exists and to see how well people perform. I think when you develop your RCM, it's not just a one and done. You want to look to see, are you over conditioning by placing the ones in those boxes, or do we need to move those over? So it's a starting point, but it's very important to continue to evaluate your pretrial program. But you want to make any changes based off of data and not based off of perception.
You'll be able to, I mean, that's good. And I just was wondering how, you said it's pretty easy for that to happen. That's good. Glad to hear that. And, you know, if there's disparities, you know, in terms of condition, you know, types of conditions, like if one group's always getting a drug testing or a AHM or something, not just release. I mean, I'm just wondering, is the data can be that level of
Again, this is, I mean,
granularity can be
to
compared and
be,
contrasted?
when they say it's easy, it is doable and achievable, and we need to build some capacity to do that. That's the biggest thing
Yeah.
that keeps me up when I say 6 to 8 weeks is we need to be ready to go with that tracking ability. Our case management system has some significant limitations. So we may need to manually track.
Has some questions.
301, I just was gonna circle back to that criminal history, right? I think the history is there where minority populations have been, you know, their criminal history, the data is pretty clear that they're usually have higher sentencings, harder just sentences and and just with how the data is put out, right? Like that criminal background, I just have a couple of questions more about that, but we are out of time. It is 3:02. So maybe I'll just circle back with Carrie at a later time to ask about this.
That sounds great.
Yeah, and I think, Madam Chair, that's a good question. I appreciate, you bring that up, because if we use a past data to be the predictor of an individual, how will perform in the future, if the data is already loaded, perhaps on the biases, how the predictor will come to play equally. And that is a great question. I will follow up with Carrie to make sure you have the answer that you're looking for.
Thanks. Well, thank you all for coming in and giving this presentation.
Robin's
sorry.
got a question.
If I could, I'm sorry, I know we're over time, but I just want to say that I think it was 2014 when the embarked on a new process around pretrial and how we might move it forward. And one of the recommendations coming out of that process was to develop a better trial assessment tool. So it's a very exciting, it's wonderful to have you all here today. And really exciting that we're this close to launching something that the county recognized a need for that many years ago. So good job and thank you all.
Yeah, I think this slide deck doesn't really represent the level of effort that has gone into this project. So thank you so much.
Pretty amazing, especially with the pandemic intervening. So really great.
Thank you.
Thank you.
Okay, it is 3:04. We are adjourned. Thank you all.
Thank you.
You guys are-